Today, we are taking a comparative look at the common and civil law justice systems. The common and civil law systems, although seemingly alike, are in fact very different. As we have seen, the courts in the UK are divided between civil and criminal jurisdiction. Thus, there is no separate administrative jurisdiction, and issues falling under this heading are dealt with by the civil jurisdiction under the heading of judicial review. The common law court system operates on the basis of what is referred to as the adversarial system of justice, whilst the civil law system is based on the inquisitorial system. Pursuant to the adversarial approach, the parties in a trial compete with each other, and justice is done when the most effective party convinces the court that their version of events is the correct one. In such a system, the judge remains neutral and limits his or her involvement to ensuring that the procedural rules governing the trial are respected. Indeed, a judge that interferes too much in a trial will be sanctioned insofar as his or her interference will be considered grounds for an appeal. Thus, in the adversarial system, it is for the parties to fight it out between them, with the state limiting its role to ensuring that the conditions of the contest are reasonably fair. In contrast, the inquisitorial system relied on in the civil law system allows the judge to become directly involved in the trial, whereby he or she acts as a type of inquisitor and seeks to find out the truth as to what occurred. The judge does this by actively gathering information and questioning the parties. Generally speaking, in an inquisitorial system, the judge determines the facts, the issues in dispute, the manner in which evidence will be presented, and the significance to attribute to such evidence. Moreover, the civil law court carries out its investigation free from the cumbersome rules of evidence imposed by the common law adversarial system. In the common law, such rules are considered necessary so as to protect the jury from inappropriate evidence. Now, let's have a look at the arguments in favour and against the adversarial system. The first argument in favour of the adversarial system is that the parties benefit psychologically from being more in control of their own situation. It is felt that because the parties are more in control of their own situation, they are consequently more likely to accept the outcome of the trial. Another argument in favour of the adversarial system is the use of cross-examination by lawyers. Lawyers, as opposed to judges, have only one ambition, namely to win the case. Thus, their sometimes aggressive questioning of a witness better tests the credibility of the witness. Another advantage is that each party gets to explain publicly their version of events, rather than the version the court wishes to hear. This is because the parties in the adversarial system define the issues to be heard by the court, and by their questions, they highlight the issues that they consider to be important. And finally, in the adversarial system, part of the expense of the system is transferred to each of the parties. As most of the work is carried out by lawyers and a jury, the costs to the state in the adversarial system are kept at a minimum. However, there are also arguments against the adversarial system. The first being the disparity between litigants depending on the quality of their lawyer. Because so much of the workload is transferred to lawyers in the adversarial system, the party with the best lawyer obviously has an advantage. Also, in the adversarial system, the court has no clear role to discover the truth. The role of the court is not to reveal the truth of what has occurred, but rather to reveal what may have happened beyond all reasonable doubt. Finally, in the adversarial system, the court's procedure is quite complicated. Because of the complicated rules of evidence, the adversarial system is procedurally more complicated than the civil law inquisitorial system. The efficiency and strength of the common law adversarial approach is in fact often viewed as a weakness by civil law lawyers, as it is felt that the common law system achieves efficiency and settlement for the benefit of the system rather than truth and justice for the benefit of the individual. The benefit or problem with both systems comes down to the same issue, namely that each system is only as good as the source of its respective strengths. Thus, clearly, in the civil law system, if the state is sufficiently financed and interested in performing its role, the accused will receive a fair trial based on the lofty ideal of revealing the truth. In the common law system, a good lawyer will, through techniques of pleading and discovery, reveal the most likely version of the truth. A weak, poorly financed, or disinterested state, in the civil law, or alternatively a bad lawyer in the common law system, will both fail the accused. However, in the inquisitorial system, that result will equally apply to everyone, whilst in the common law system, it is mainly the poor who pay the price of a bad lawyer. Although the use of contingency fees seeks to overcome this limitation. We hope you enjoyed this introduction to court procedure in the common law.